background.
Muted.
Before I introduce our esteemed speakers, I wanted to make some brief announcements. First, if you would like to follow along with our panelists today, a copy of the NAA Toolkit is available to you in the handout section on GoToWebinar. Also, as an update to the toolkit, the assistance animal reasonable accommodation policy that Kirk will be discussing today is available in the handout section as well. Please remember, this session is being recorded. For those of you who want to send this to your colleagues or other staff at your company, the webinar will be housed on the NAA website along with the resources I just mentioned, and we will send out more information post-webinar to attendees as well. Also, I wanted to remind everyone that this session counts for 1 continuing education credit for credential holders. After the event, we will work with NAA EI staff to put together certificates. The certificate will be sent to the email address you used to register for the webinar. So if you're logging in with multiple people, please email me at nupano, U-P-A-N-O, at naahq.org if you need a certificate and we do not have your email on record. One final note, please feel free to submit questions at any time during the webinar using the questions box in GoToWebinar. We will get through as many of these questions as we can during the Q&A section. If not, we'll try to do some follow-up afterwards. Okay, so let me introduce your speakers for today's session. First up, we have Katie Wren. She is a Regional Training and Marketing Director at Milestone Management. Katie joined Milestone in January of 2008 and has almost 15 years of industry experience. She currently works with over 50 properties across 4 states within the Southeast. She is an NAA EI Advanced Instructor, a graduate of Ursuline College, and currently holds her CAPS designation. Also a Florida Apartment Association and National Apartment Association Leadership Lyceum graduate. Katie is the president of the First Coast Apartment Association and a delegate to FAA and NAA. And Katie is an active member of FCAA's Education Committee and provides instruction for a variety of designation classes, including the NALP, CAM, and CAPS. And thank you, Katie, for speaking for us today. We're also pleased to have Kirk A. Cullimore. He is the owner of the law offices of Kirk A. Cullimore, LLC in Sandy, Utah. His practice is focused primarily on landlord law, collections, and fair housing. His office represents many companies, including NAA members, Alliance Property Management, AMC, Bridge Property Management, Greystar, Horizon Realty, Milestone, Millwood Management, Cornerstone Residential, Mission Rock Residential, Peak Living, Thompson Michie Associates, Pinnacle Realty, Wasatch Property Management, Bach Properties, Pentalon Corporation, and Triton Management. He received his BA from Brigham Young University in Financial and Estate Planning and his JD from Wilmette University in Salem, Oregon. Mr. Cullimore has served as chairman of the Utah Apartment Association. He has also sat on the legislative committee of NAA and served as a regional vice president of NAA. Kirk has lectured frequently across the western United States on issues relating to landlords and fair housing, and he served on the National Apartment Association's Task Force on Assistance Animals. And you can learn more about the task force's work in the NAA Toolkit. Kirk is the father of 10 children and grandfather of 22, almost 23. All right, well, and thank you to Kirk as well. And now I'd like to turn things over to Katie. Katie, would you start us off?
Thank you so much, Nicole, for those introductions. Good afternoon, everybody. So today we are going to go ahead and advance our slide first. Give me 1 second to make sure I have control. Thank you. All right. Sorry about that. I want to make sure we're all set to go before we dive in here. So today we'll be defining and understanding the laws that govern reasonable accommodations and assistance animals. We'll discuss how to work within those laws and also how to manage those requests. So in the rental housing industry, there are approximately 27,000 fair housing complaints filed in 2011. Nearly half of these complaints were based on disability, and recent trends show that complaints frequently involve service and emotional support animals. So before we dive into the laws, I want to go ahead and start with two case studies that we may refer back to throughout the presentation to help you understand the impact that complying and managing reasonable accommodation requests and how important it is. So the first case study was in 2012. A 776-unit community violated fair housing by denying a resident with a psychiatric disability a reasonable accommodation for emotional support animal in the community by having a no pet policy which limited the use of that assistance animal. This actually resulted in the community having to pay $15,000 in monetary damages. They had to establish a $15,000 settlement fund in the event of additional violations, and the community had to adopt a reasonable accommodation policy as well. Their employees had to undergo education and training, and they also had imposed reporting and recording requirements on that community as well. So overall, this resulted in $40,000 to be paid out. That doesn't include attorney's fees, employees' time to develop the policies for the community, the time spent for training as well. So that number really goes well beyond that $40,000. In a second study, again in 2012, the community property manager prohibited a resident with a disability from keeping an emotional support animal. The community required the resident to pay fees and required them to purchase liability insurance for the animal. When the resident refused, they non-renewed the resident's lease agreement. So this former resident ended up being paid out $20,000 in damages, and the property had to adopt new policies to remove all fees and insurance requirements for service animals. So this impact, know that it's not just your company that can be impacted, but it can be you impacted personally as well. So it's really important that we have a good understanding of these laws and how we can manage them and work through them. So let's start by defining the laws that pertain to rental housing and assistance animals. So the Federal Fair Housing Act is going to prohibit discrimination on the basis of disability in housing and applies to almost all rental housing. Section 504 of the Federal Rehabilitation Act applies to housing that receives federal financial assistance from HUD. And then we have the Americans with Disability Act, and that's going to Title II of the American Disability Act is going to prohibit discrimination on the basis of disability in public accommodations. Title III of ADA applies to public and common areas and housing that are accessible to the public. For the most part, ADA is going to stop at your leasing office because that's usually the only public place on your property, but we'll talk further about that. I also want to talk about state laws as well. And most states are going to mirror the federal law. However, state and local laws could extend beyond that. Any state and local law ordinances that deals directly with these issues, for the sake of the presentation and toolkit, has not been taken into account. We are not aware of any states that have those laws. However, we do know that several cities in California have enacted ordinance that would affect this discussion and conversation. So that's something to keep in mind if you fall within that. So now let's define an assistance animal. Under the Fair Housing Act, in Section 504, an assistance animal works to provide or perform a task for the benefit of a person with a disability or provide emotional support that alleviates one or more symptoms or affects a person's disability. Know that assistance animal does not need to be trained or certified, and under fair housing, an assistance animal can be quite a few things. It can be anything from a snake to a dog, to a turtle, to a ferret, to a cat. That list can go on, but I'm going to shorten it up for today. Then we have the American with Disabilities Act, and ADA defines a service animal as a dog that is individually trained to do work or perform a task for people with disabilities. It does exclude companion or emotional support animals, but miniature horses are included in their separate provision. We're not going to go too far into that today, though. So I kind of want to break down assistance animals because there's several terminology. The terminology of assistance animal is kind of an umbrella term for all animals which a qualified disabled person under Fair Housing or Section 504 has requested an accommodation. So a service animal is a subsection of an assistance animal, and they're generally animals that have been trained to perform a specific task or function for a disabled person. So for an example, a dog that may alert somebody when they were having a seizure, or a dog that's trained to assist someone with a hearing impairment. Then we have emotional support animals and companion animals. Sometimes you will hear those two words used a bit interchangeably. But that animal provides emotional support to a person with disabilities that may need such support. Then we have a therapy animal. So the most common usage, an assistance animal, is not an assistance animal. So your therapy animal, the goal of like an animal-assisted therapy is to try to improve the social, emotional, or cognitive functioning of a person to enhance someone's quality of life. But generally, in its most common usage, that therapy animal is not covered under the assistance animal. One thing that's important to know, that an assistance animal is not a pet. So we're never going to refer to an assistance animal as a pet. We're never going to charge them pet fees, pet rents, or pet deposits because they're not a pet, they're an assistance animal. I want to take a stop and go over another case study that kind of goes into this and what can happen as a result of referring to a pet and holding those pet criteria. So in this case study, it was actually a fair housing tester visited an apartment community. The tester told the employee that she was looking for an apartment to rent and revealed that her husband had a service dog for his disability. The employee explained that the pet has $400 deposit and $40 a month pet rent per month for her dogs. The tester asked whether the fees would be waived for her husband's service dog, and the employee told the tester that the pet deposit would be waived only if the dog was trained and certified. So there are three errors in one situation. So first of all, you cannot require a pet deposit or a pet rent because a service animal is not a pet. You can also not require the dog to be trained or certified, as a service animal does not require training or certification. Know that those certifications can be bought online. I can go online right now during this webinar and purchase a certification. Or a lot of things that come up is the red vest that say service animal on them. I found today that on Amazon Prime I can have one for a great cost of $34.95. So those can be bought, so those really don't mean much, not to mention you can't require any training or certification. So to continue with this, the Fair Housing Center actually continued to test the community, still found discriminatory practices. The center ended up mailing approximately 900 brochures and educational literature about reasonable accommodations to this community's residents to educate them on fair housing rights of a person with disabilities, and ultimately the community ended up having a complaint filed against them. So again, a really great example of what can happen and how those situations may transpire and what they can lead to. So now that we have defined what dictates an assistance animal, let's look at how that assistance animal applies to fair housing. So a reasonable accommodation is a change in rules, policies, and practices, or a change in the way services are provided in order to enable a person with disability to have equal opportunity ensuring full enjoyment of a unit or living space. A housing provider must grant that reasonable accommodation or modification if the request is made by a qualified handicapped person and meets the requirements established for a disability-related need. Know that the individual does not have to mention the Act or Fair Housing Act or reasonable accommodation to make that request. However, they must make that request in a manner that is reasonable, that a reasonable person would understand. So let's define handicap under fair housing. Getting a little ahead of myself there. All right, so handicap is a word that's used in the Fair Housing Act. However, HUD and other agencies started using the terminology disability or disabled. For the purpose of this discussion, these words will be used interchangeably, and also when you go back and look at that toolkit as well. So handicap means with respect to a person having a physical or mental impairment which substantially limits one or more of such person's major life activities. So I want to talk about what exactly is a major life activity. It's an incredibly broad term, and that can be anything from caring for oneself, performing a manual task, seeing, eating, sleeping, walking, lifting, bending, thinking, communicating, and even can go into major bodily functions such as respiratory, circulatory, neurological, or even immune systems. The list can go on from there. But number 2 is having a record of having such an impairment. And number 3, being regarded as having such an impairment. It does not include current or illegal use of addiction to a controlled substance. So if a current abuser would not be covered here. So now that we've defined a reasonable accommodation, some of the laws that pertain to it, and we've broken it down a little bit what exactly an assistance animal is, I'm going to go ahead and turn it over to Kirk, and he's going to discuss how to manage that process when a reasonable request is made.
Just one moment, folks. We're having some technical issues. Kirk, do we have you on the line? Katie, could you go on while we try and figure out this technical issue?
Sure. I don't know. Kirk's got some big shoes to fill, but yes, we'll keep going. All right, Kirk, when you get on the line, just let me know and we'll let you jump on in. So, as I said, Kirk was going to begin to talk about how to handle when a reasonable request was made, and then how to manage that process as well. So, a reasonable accommodation request for assistance animal. Let me get us to the appropriate slide. Although the request does not have to be in writing, the housing provider are entitled to have a request made for reasonable accommodation. So the accommodation, we should have a process, we should have forms in place that to be put into writing when someone makes that request. However, if they go ahead and make that request verbally, we are still responsible to move forward with that request, even if it's not put into writing. We can also go ahead and help them we can help them write that out as well and put that request in writing. Having it in writing is important because it's going to help kind of keep everything clear, and that's obviously the best case scenario, so that we know exactly what somebody is asking for, and they're writing it down in what they want as well, so there's no miscommunication there. Although if a verbal request is made, we still have a responsibility to review that request for a reasonable accommodation. Once that request is made, then it then falls on us to determine whether it's a reasonable accommodation, as well as obtain sufficient information to identify whether this is truly a reasonable accommodation that request we're going to approve or deny. Although specific forms have not been provided by HUD, certain forms and policies have been improved through conciliation agreements. So in your NEA toolkit, you're going to see several forms in there that, while HUD will never definitively say, yes, these are approved, the law offices and NEA has worked with HUD, and they said these forms are good, and you'll find those in your NEA toolkit. Every company as well should have a written policy on handling a reasonable accommodation request to ensure that we are handling each request in a same manner. So I think we now have Kirk on the line. Kirk has covered this slide that's on the screen if you are able to take over.
Can you hear me now?
We can hear you.
Yay, sorry about that. I don't know what happened. All right. But Nicole, I still can't take control of this for some reason. It's not letting me move the slides. Oh, there we go. Well, So I appreciate you being here. Let me, I really want to talk about how we make these, how we get the requests and what we do when we get them. You know, generally when a tenant comes in to request an accommodation, it takes the form of one of three things. Either they come in when they're applying and tell us about it, or after they become a tenant, they come in and tell us that they have a need and ask us to grant that. And I'd say probably most often it's we catch them. They have an animal, and all of a sudden that animal that we catch becomes an emotional support animal or a assistance animal. Regardless of which way it happens, the process really should be very similar in terms of qualification of that animal. It's important that we remember that we're not qualifying the animal, but that we're qualifying the person. Under the Fair Housing Act, the animal is really the wheelchair. It's the device necessary for the person that is handicapped. And so we're not qualifying the device, we're qualifying the person to determine whether or not they need the device. So there's really two issues on all of this. And one is we have to determine whether or not they meet the definition of handicap as we've discussed. And two, whether or not there is a nexus between the handicap and the need for the device for the animal in this case. In doing that, we've created some forms and some processes to assist you in making sure that we have a consistent process that both protects you and yet gives us the opportunity to make sure that those people who had abused the system are somewhat ferreted out. We're never going to be able to get them all out, but we are trying to do the process some way. It's important that if you're going to have forms and instructions that you read them, know them, and use them to be consistent. What we're presenting to you today and what's in the NAA toolkit are some forms that have been approved as much as they can be approved in conciliation agreements with HUD in Denver, although we've had other regions also accept the forms at this point in time. There's three parts to the form. One is the resident's request for an assistance animal, and as we've discussed, we can ask for them to put it in writing. We can't require them to put it in writing, but we generally recommend that you go ahead and use this form to ask them to put it in writing, and if they cannot, then you help fill it out and have them sign it so we know what the request is. The second form is an animal identification form. This really is just very simple, and it should be used for all assistance animals and for every animal on your community, so it doesn't appear that we have an animal identification form that is only for assistance animals. So if you allow other animals in your community, you should use the same format and form for identifying the animals, whether they're an assistance animal or a pet. This form has been negotiated and created, and we'll talk about it in just a second, that has information on it that assists us in both the qualification and maintenance of assistance animals. The final form that we'll show you is a verification for assistance animal. This is the form for the medical provider, health professional, social service professional to give to us, and it can also be used as a guide in the verification process as we talk about it. Now, it should be noted that if the person making the request already has a note, a letter, a prescription, some other documentation from a medical professional, health or social service professional, that it's not necessary to give them the verification form. You just give them the other two forms. The verification form should still be printed off and still be put in the file and used in the verification process, but it's not something that we would require them to go back to a medical provider and have it signed again. All right, here's a copy of the first form, and these can be found in the toolkit as well. This is the request for the assistance animal, and as you can see, it's fairly simple. It talks about what the definition of handicap is. It requires them to affirm that they are handicapped and that they qualify, and they can tell us what the anticipated length of the disability is. We're not trying to trick them, but you should be aware that if they actually put a date in there, that might be an indication that this is not a true handicap that would qualify them for an animal. It's not a red flag by any means, but it's something to look at and look at. This gives them the name of their primary care physician and telephone number so we can do verification. And then it makes the request and has them sign it. So this is just a form really to put in our file that shows that the person made a request for an assistance animal. Let's go to the next slide. The next form, there we go, is the identification form. I want you to know that we negotiated this with HUD, and so there are things in this that we think are helpful. We had to take some things out of it that we've seen in other forms, and I would caution you to be careful about what you request when you're dealing with an assistance animal. I get questions all the time about, well, can we require that they're current on their shots, and can we require that they be spayed or neutered? And the answer to all of those is probably not. You can't at least make that a definitive requirement in the format. So what we've negotiated basically is what this says. We ask what the type of animal is, the breed, the age, the weight, the color. They don't have to have special training or certifications, but we can still ask if they do. And this is where they would put that down. The next one is the important question. Have they ever been reported to any authorities, for police or animal control, for any incident? One of the ways that we can deny an assistance animal is if they would be a danger to us, to the community. And the evidence of that would be if they'd previously been reported to the police or animal control for incidents of biting or aggressive behavior or things like that. Again, may not be a black line that says we absolutely can deny them, but it is one of the factors that we can look at if we are going to deny an assistance animal. Underneath that, it talks about some other restrictions that we have in there, that they can, they're supposed to be with the person and on an approved leash. Again, most of you know that we can require it to be on a leash unless they come in and ask for a second accommodation that says my dog can't be on a leash or I can't control the leash, and then they just have to show us that they have the ability to control the animal, and we may have to make a second accommodation to not require the leash. Animals may be restricted from specific areas. That's not 100% accurate. They can be wherever their tenant is, but the HUD agreed that we could put that into this agreement because things like most ordinances don't allow them to actually be in a swimming pool or spa, although they can be in the area of it. They're not supposed to be in areas where food is being prepared. And so you need to look at your local ordinances and regulations on where they might be restricted based upon local ordinances. Obviously, we're putting in the rules and regulations somewhat. They have to be responsible for cleaning up after the animal. They're responsible for any damage done. They can't disturb the peace, and that we can implement other rules and regulations relating to animals. Finally, we require them in this form to affirm that their animal is in compliance with all state and local laws concerning animals. This is kind of the catch where HUD allowed us to put in that if your city or county requires licensing, then they have to affirm that they're in compliance with that law. And if they're not in compliance with that law, we may not be able to deny the initial request, but subsequently, if we find out that they're not properly licensed, it's a violation of the agreement, and we can take appropriate action at that point in time. And then we want them to sign this. And again, if they can't fill it out, we help them fill this out. And this form should be used not only in assistance animals, but for all animals on the premises, whether they're pets or assistance animals. The next form is the verification form. The verification form, again, would only be utilized if they didn't have in their possession at the time. We give them this document to take back to their medical professional in the event that if they do not already have a form, a prescription, a letter, or something like that. If they already have one, we should still print this off, because this is going to be the template that we'll use when we actually make the phone call to the provider to verify the information that they've given to us. This verification process is the important part of what we're trying to do in the industry. If we do not follow through with verification, then essentially these forms aren't going to help you at all, because we're not taking the steps necessary to both educate the medical professionals that are out there and to require them to verify the information that they've given to us. As you can see on this form, it asks some information, and so even if the medical professional has already filled out this form, you would still use it as a template to call them back and do the verification process. At the bottom it says signature of medical provider, health or social service professional. I provided you also an assistance animal policy that's part of the handouts here. I would encourage you to go back and look at that, because although we would like a medical provider or health or social service professional to sign off, particularly when we're dealing with an emotional support animal, there may be other people that have sufficient information to provide verification for an assistance animal. And so although we put that as a signature line to try and encourage that that's who we're looking for, there will be instances where it could be somebody other than a medical provider to do it. The best example of that would be if a not significantly autistic child was turning 21 and wanted to move out on their own and was capable of living on their own, and had been received an emotional support animal to assist with their autism back when they were a child. If the mother came in and affirmed both the disability and the need for the animal, she's probably in a better position to give that kind of verification than a medical provider would. And so often we need to be careful that we are not stuck on format and forms, and that we remember that we have a policy that we have to go back to and be flexible in terms of looking at what they've actually provided us, and does it give us sufficient information to be able to make a determination whether we're going to grant or deny the accommodation that they're requesting. So once these forms have been filled out, or we've received everything, we're going to review those forms and start the verification process. And verification is just that. We're going to confirm the information by speaking with the person that actually signed the form or provided the prescription or gave us the letter, or whoever. The medical, health, or social professional that in fact executed the document is who we want to talk to. So if their nurse gets on, if their assistant gets on, if anybody else gets on the phone, that's not sufficient for us. We want to talk to the person that signed the form, because they're the ones that are responsible for signing the form. Once we get them on the phone, which may be a difficult process, I can tell you from my experience that it may take 2 or 3 phone calls, and how many phone calls we make is probably determinative of how the process started. If this is a new tenant that hasn't moved in, then we can make a couple of phone calls to the doctor to try and get a return phone call. If it is a existing tenant who we caught with an animal, we may shorten that process, although we may still make a couple of phone calls to try and get hold of them. We aren't going to give as much time for a response. Once we get them on the phone, and we'll talk about what happens if they don't respond or whatever, but once we get them on the phone, we are going to verify the information that the medical provider has provided. And we're going to use that by using the form, the verification form that we have. And some of that is just going to be a factor of actually just reading the information to the doctor. Something very similar to this. Dr. So-and-so, I appreciate your time. I know that you're very busy, and I would like to be able to verify some information on your patient, John Doe, wherein you have signed a form, prescription, whatever, stating that he has a need for an assistance animal. As part of our process, we verify that information. The first thing we want to verify is, did you sign it? Is this really a form that you signed? Did you execute this document? My experience has been that you're going to have 5 to 10% where they have no idea what was signed and they didn't sign it. And you want to be cautious about seeing that. I'll put a side note on this, and that is when you make the phone call, you want to listen to how it's answered as well. I've had more than one instance where I've called and it was a cell phone that I ended up getting hold of, and ultimately found out it was just a friend who was posing as a doctor in order to assist his friend to get this assistance animal. But you also ought to listen to how they respond, even if it's an office. It obviously raises red flags to us if they answer, Mountain View Pediatrics, and the assistance animal request is for a 52-year-old man. Doesn't mean it's not accurate. It just means it should raise a red flag for us. The same as if they answered dental offices or chiropractic offices. It doesn't mean that we aren't going to accept this, but it should raise a red flag on why we are calling somebody that would not typically be engaged in assisting somebody in obtaining an assistance animal based upon an emotional support animal based upon a mental issue. That being said, if they, we want to read to them what the definition of handicap is. Now, the word is handicap in the Act, and that's the word that we probably should be using with the medical providers. Disability tends to be a little bit of a softer term, and because of the easy availability of things like disability parking stickers and things like that, the medical professionals tend to take the word disability as a lesser standard than handicap. And so I would encourage you to read what the Act says rather than using the more politically correct and current terminology of disability. And so we asked them, Dr. So-and-so, is John Doe handicapped as defined by the Fair Housing Act, which means that he has a physical or, again, I'm sorry, I don't have it in front of me here, I should have had it, that substantially limits one or more major life activities. Those two words, substantially limit and major life activities, are the two things that we should be keen on when we ask them that question. Many of the doctors and medical professionals will ask you what those mean. As Katie has told you, we can give some definition on this, but we really just need to stick to the Act. Do they have a substantial limitation on a major life activity? And if the doctor says yes to that, the next question is there a nexus? Will this request somehow assist in ameliorating that handicap? Obviously, if the doctor says yes to both of those, the medical professional says yes to both of those, then what we're going to do is try and take an opportunity to educate the doctor a little bit. And we want to read the middle paragraph in that verification form that basically tells them that by signing the form, they're requiring us to accept this animal without the normal pet fees and other deposits that other people have to pay, because the animal is no longer a pet, it is a medically necessary device. After you've educated the doctor a little bit, ask them if they have any questions, thank them, and be done with it. And we're probably going to have to accept the animal at that point because we've got the forms and we've done the verification. Now, you should note, nowhere in that verification process did I ask what the disability was. We still can't do that. But you'll find that in the vast majority of cases, once you ask the questions, they're just they're going to tell you everything you need to know. Now, these forms are critical for us to be using, particularly in emotional support animals. Although HUD would like us to assume that we're treating all assistance animals in the same light, the reality is that we have a standard that deals with readily apparent that is much easier, much more easily met with true service animals than it is with emotional support animals. And the truth is, in the industry, we don't have a problem with service animals. Most people that have a legitimate service animal are more than happy to let you know what their disability is and what their animal does for them. I don't think in the, since this has become an issue in the last 20 years, I've had a single instance in dealing with a problem with a service animal, at least not a true service animal. But the emotional support animals have become kind of a plague because they appear to be so easy to get a doctor or somebody to do that. Okay, Nicole, let's go to the next one. So once we've verified and everything looks in place, we ought to both put the approval in writing. If the medical professional doesn't verify the information, or in the conversation denies it somehow, says, well, no, they're not really handicapped, we really don't need to go any further. We can write right on the form, talk to the doctor on this date at this time, the doctor stated they were not handicapped, and then we can give a denial letter basically saying we are denying this because your doctor did not verify that you met the definition of handicap. In addition, if the doctor won't talk to you or refuses to call back, then we have a conditional denial, because we can let at that point we should be putting the burden back on the tenant to get the doctor, medical professional, to respond. And basically we're telling the tenant that we cannot grant the request until we've been able to verify. And as a consequence, it is their obligation at that point, if we've made an effort to get hold of the doctor, medical professional, to get their person to call us back. And we can do that in the same way. We should give them written notification that their medical professional has failed to respond to us, or even if the medical professional responded but would not talk to us because we didn't have a HIPAA form, the same thing. We give the tenant back the information that we could not get verification, and as a consequence, we cannot grant the request at this time. So we're not technically denying it, we're just not granting the request at that point in time. Now, if you get a request for a HIPAA form, HUD really doesn't like the HIPAA form when it comes to this, because it's too broad of a form, and we had discussions multiple times about modifying the form and making it less broad. Ultimately, the decision was basically that they just don't like it and they don't think we need it, and so they don't want us to use it. And so our call is not to obtain new information, it is to verify the information that they've already given to us, or the information that we still need in order to grant the request. Most of this information is not asking about the disability or the handicap. It is trying to verify that they have a handicap and that they have a need. Those don't fit under the HIPAA requirements, and so if a medical professional refuses to talk to you relating to that, that's just a refusal to provide verification, and we don't have to grant the request at that point in time. After you've had the discussion with the doctor, you may want to review other documentation with the doctor. Often we find that the doctor signs the form, the medical professional signs the form, but that the tenant doesn't fill in what type of animal or what animal they're getting until after it's already been signed. And often I find that if I let the doctor, particularly if it's an unusual animal, I try to let them know in the process what animal it is they're requesting as an assistance animal. Sometimes that makes a difference. If they're asking it for an animal, though, that is not allowed in the area that they live in, we can still rely upon those local ordinances to potentially deny the animal. That potential denial is basically a denial that says, based upon our local ordinances, we cannot grant this request unless you can receive a variance from the local government officials that would allow us to let you have this animal. Generally, they'll grant those variances if they can truly show it's an emotional support animal. But we can make sure if we, for instance, if you live in within a city limits that does not allow farm animals, we can deny a assistance goat unless they can show that that assistance goat they can obtain a variance from the city that would not allow that to live in the city. All right, let's go to the next slide. We talked a little bit about this, but remember, once we've qualified an animal, you can't charge pet fees, pet rent, pet deposits, or any other fees relating to the animal. We can't restrict assistance animal on the basis of size, weight, breed, or other criteria, again, except as may be allowed by your local ordinances. The assistance animal can accompany the resident anywhere the resident can go on the property. Again, accepting local laws or ordinances that may prohibit them from being in swimming pools, hot tubs, areas where food's being prepared. This doesn't apply, though, to other people. So if it's a husband and wife and the husband qualifies for the assistance animal and the wife does not, the wife can't be on the property with the assistance animal, just the husband can be, unless they're in compliance with it. So the assistance animal has to accompany the person that qualifies for the animal. All housing providers should have animal rules for their communities, even if you are a no-pet community. You're going to have animals. We're going to have assistance animals. We're going to have service animals and emotional support animals. And so you need to generate rules to protect you and the other residents relating to how animals can abide within the property. And then ultimately, you just need to remember, an assistant animal has to abide by those rules, and the person that qualified their animal is responsible to make sure their animal abides by our rules. Rules violations, damages, or a nuisance still qualify for the same process that would exist for any other type of rule violation, damage, or nuisance. The fact that it's an assistance animal does not grant to it any exceptions to the normal rules and regulations and peaceful enjoyment required within an apartment community. Next slide, please. Can we deny a specific animal if it poses a threat to the safety or health of others? We can, unless we can, and they can show somehow that they've been able to reduce or eliminate that health or safety issue. Generally, you're going to find that obviously in advance if they have to notify you that they've had a previous incident with the animal. And much like every other thing in a reasonable accommodation, you're going to have to look at that issue and make a determination whether or not that animal does in fact pose a threat to the safety or health of others in the community. And if it does, we can deny it. Once we've accepted the animal, if it causes a problem, that's a violation of the rules. So then we don't have to look at whether it poses a threat or to the safety or health of others. They violated our rules. And the violation of the rules, depending on how egregious, will entitle you to move forward with whatever processes to evict the tenant for violation of the rules. If you can determine, though, that the animal has a history of repeated nuisance and property damage and physical damage or any of those kind of things, and the tenant has not been able to show you a means by which they have resolved that issue with that animal, we can deny it. Now, I often get the question, and particularly from many people that love animals and love dogs, that say, hey, most of the time when you have a problem with an animal, it's not the animal, it's the person that's supposed to be controlling the animal that's a problem. I do think we can take that into consideration, particularly if you find that that person has had multiple animals and each of those animals has had a problem. But that's going to be a little bit more difficult in the process, and there'd have to be some record of showing it. Obviously, the law allows us to deny any reasonable accommodation request if granting the request would impose an undue financial or administrative burden or fundamentally alter the nature of the housing provider's services. I don't know that I've ever seen a case or a circumstance where dealing with assistance animals, we were able to meet that issue. We've been able to propose some theoretical ones. For instance, somebody who felt that their horse was an assistance animal, was their emotional support animal, and needed the ability to have the horse nearby, might impose an undue financial or administrative burden to do it. The fundamentally alter the nature of the housing provider services. I've had somebody argue, and I don't know that I disagree with them, that if you created a community that was intended for people who had significant allergies or fears of animals, and that the only people you rented to met that kind of qualification, that may significantly alter your services and do it. But I don't know of anybody that has that. And so those are the only ones that we see have even considered that might meet those things. Generally, I think to rely upon undue financial or administrative burden or fundamentally altering the nature of your services is not going to assist us very much when it comes to assistance animals. Next slide, Nicole. I'll go through this pretty quickly. Just remember the ADA rules as they apply to us only apply to our leasing office or any other potential common areas that we allow open to the public. One of the reasons that we recommend that you not allow third parties to come in and use your amenities for services for people in the community is because you may have opened up your community to ADA rules and requirements as well. For instance, if you allow your swimming pool to be used by somebody to teach swimming lessons who get to invite people that are non-residents onto the property, you may have just opened your swimming pool up to the ADA rules relating to not just animals, but to other ADA rules. And so the ADA rules really just stick to the areas where we offer the public to come in, which is generally just our leasing office. And remember, the ADA says it's got to be a dog in almost every instance, and that we can ask, is this a service dog that is required because of a disability? If they say yes, we can ask, what work or task has the animal been trained to perform? Those are the two questions. I don't think generally we have much of a problem with this because when people are coming to our leasing office, we're trying to sell them on the community, and so we're not trying to turn away those type of animals. However, just remember that our leasing office is only place that applies, the ADA applies, and it's only for dogs. And so you need to make sure that you're careful about that. Okay, next. Let me go over a couple other subjects that may help you a little bit. Multiple assistance animals. Obviously, you can look at local ordinance to see if they have restrictions on the number of animals that can be in a single-family dwelling. As many of you may know, those have been challenged by HUD somewhat, saying that although you're saying you can only have so many animals, that an assistance animal really is, it's not a pet, and so these rules shouldn't apply. But people are going to ask for multiple ones, and we should be requiring them to have the same doctor on the same form make the request. Often we've found that if they use multiple medical providers, those medical providers are not aware that they are asking for multiple animals. They think it's just the one, and so we should have a process to make sure that we are asking a little bit more detail on that, making sure the same medical provider is opining that they need multiple animals. And this is probably a point where you can ask the next question on this, which is, what does the second animal do that the first one doesn't? Particularly when we're dealing with emotional support animals. Often the answer to that is that the doctor will say, well, you don't know how hard it would be for them to get rid of one of their animals. These animals are just like their babies. That doesn't meet the criteria, because we're now saying that the effect might happen if they have to get rid of the animals. There's not an effect. The nexus doesn't apply right now. It may only apply after they have to get rid of the animal. And so we ought to be a little bit more difficult when it comes to multiple animals for the same individual. That does not mean that if there are multiple animals within the same unit that you have to require the same medical provider if it is for different people. So if you have 3 tenants and each one of them have a separate doctor and a separate form, you cannot require the different people to use the same medical provider. The other thing to look at is the age of the prescription. Often we've seen these notes or letters or something that are 6, 8, 10 months, 2 years old. If this is a new request, particularly dealing with emotional support animals, it's probably not unreasonable to ask for that to be updated if it is more than 90 days old, to ask them to get it in. Again, you may want to look at specific circumstances when you do that. There's a lot of internet certification of animals, and I just remind you that we don't certify the animals, we certify the person. And so any documentation they have on their animal, unless it relates to service animal training and they've already established that they are handicapped, we don't care about the certification process. Just so you know, I've gone to a couple of those websites, and I got one of my children certified as a assistance animal, and so it's just that easy. Guests with assistance animals, the Fair Housing Act does not generally apply to guests, and so we do not have to allow guests with any kind of assistance animal on our property. I would recommend that you have a policy that says guest animals may not be on the property without receiving prior written permission of the management, and the only animals that you would allow would be true service dogs that would come on. Answering questions on assistance animals and no-pet communities, I'd refer you back to the toolkit. It's got all kinds of answers to those questions. Out-of-state medical professionals, we see a lot of this going on right now, particularly internet professionals. There are 5 or 6 websites across the United States where there are therapists who, for a fee, if you fill out a form, will send you the letter. I generally recommend that you deny those, but it's a case-by-case analysis. You want to make sure that this is a true medical professional that is properly licensed and has a license that may cross state boundaries. For instance, MDs, generally their licenses cross state boundaries. A marriage therapist has to be licensed in each state. And so if there's not some connection between the tenant and the professional, where the tenant actually used to live in the state and actually met with that professional, those are suspicious, and you ought to be talking to your attorneys, and if you get one of those, give me a call and I can talk with you about them, because there's a lot of there's 4 or 5 of them out there that are flooding the marketplace for next to nothing, and they don't even meet with the people. There's no Skype, there's no connection, they just do it off of a form. Okay, I think I've gone way over, Nicole. What's their next slide, and then we'll open questions here. Nicole, you want to take back over?
Sure. Thanks, Kirk. Well, thank you, Katie and Kirk. Those were great presentations, and we really appreciated having you today. I think before we open up the floor, Kirk and Katie, if we could address some of the questions that came in via GoToWebinar. Kirk, if you could answer, we had a good question come in from Linda Rossi. She said the bottom of the forms indicate that they cannot be reproduced without permission. As an NAA member, can we use the forms that are presented in the toolkit?
Good question. The answer is absolutely. Although we copyrighted these forms when we created them, we've given them to NAA, and all NAA members can use anything that's in the toolkit without having to ask for any permission on it. And so please feel free to use these forms, and I actually encourage you to use them. Yeah, I think it will help us all.
Thank you, Kirk. I know we're right at 4 o'clock right now, but if you could bear with us and you can stay for a couple more questions, that would be great. If you have to go, we will do some follow-up and make the recording and the resources available after the webinar. So please look in your email. We'll do a follow-up email with a lot of information. Okay. All right, another one of the questions that came in, we had two people who had very similar questions. Christina Chumley asked, what steps can be taken if an animal is aggressive against other pets in the common areas? And similar to that, there was a question from Mike Kivitz, which says, if an animal is an aggressive breed and has a habit of lunging towards residents and our team members, how would you proceed?
Well, my answer to that is fairly simple. I think that that if you have animal rules, they should include that there cannot be any aggressive behavior or complaints about aggressive behavior of the animal. I generally recommend that you don't, that warnings, this is kind of a no repentance, no forgiveness type situation, particularly in the no pet communities, that you basically give them a chance to give them the rules and tell them what they have to do, and then we expect their animals to comply and expect the owners to comply. And so, if there was a history, we deny the animal. If it happens after we've accepted them, you're going to have to look at whether you have enough evidence to establish that there's a violation of your rules and regulations and your animal rules. And if there is, then I would take the appropriate action to give notice to the tenant that you're going to evict them unless there can be a remedy to the situation.
Okay. Thank you, Kirk. And let me unmute everyone. I'm sorry, it looks like we're having some issues with the system again with muting people. If you do have questions, please do email me. It's nupano, N-U-P-A-N-O, @naahq.org, and we'll get those questions answered. We seem to be having an issue with muting everyone again. My sincere apologies. Well, thanks again for joining us for the webinar, and please look in your email for some follow-up. We will make the recording and the resources available, and also the certificates for continuing education credit. So thanks again, everyone, and my apologies for the technical issues.